Mr. Upshaw, do you need a breakout room with defense attorney or plaintiff's attorney?
Ms. Francis, do you need to speak to Mr. Upshaw?
If he would like to speak, Your Honor.
Mr. Upshaw? Mr. Kirschenheiter, you're on the web matter.
I am, Your Honor.
Have you spoken to Mr. Webb?
I have not. I'm happy to if he'd like to speak. I'm just not sure if it'll be fruitful.
Understood. Mr. Webb?
Yes, Your Honor.
Would you like to speak to the attorney, or are you ready for me to call the case?
Either or.
Neither of you sound particularly excited at the prospect of speaking. So let's just call the case. This is 225251GC. This is Portfolio Recovery versus Ryan Webb. May I have your appearances, please?
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722.
Ryan Webb
State
for
your name,
myself.
please, sir.
Ryan Webb.
Thank you. Today is the day and time set for the pretrial and the plaintiff's motion for summary disposition. Mr. I just lost my screen. I'm sorry. Mr. Webb, did you receive the motion from the plaintiff's office?
I did, Your Honor.
Did you have a chance to review it?
I did, Your Honor.
Mr. Kirschenheiter, please proceed with your motion.
Thank you, Your Honor. As you indicated, this is plaintiff's motion for summary disposition. It's a C9, C10 motion. We have provided statements showing use of the account as well as payments on the account. We provide proof of the assignment, the bill of sale and redacted line item, as well as an affidavit as the amount due and owing. We don't believe there's an issue of fact. We don't believe a valid defense has been pled. There was no affirmative defenses in the answer to the complaint. I don't know if the court has received a copy of defendant's response. It was hand delivered to my office on Friday, which is not timely. So I'd ask that the response not even be considered. But I'll let defendant speak to that, Your Honor.
Thank you. Mr. Webb, this court does not show a response to the motion, sir. What was your response?
Yes, Your Honor. I did deliver that to the courts as well. So I can send that to you, or I can read it to you, whatever's best.
Please read it to me since we're on the record.
Absolutely. In response to paragraph 1, the plaintiff's portfolio recovery associates is not attached to the original contract. Therefore, I could not outrightly admit the allegation. And then furthermore, to paragraph 8, I would deny the reason the same untrue for the same constituents. Conclusion of law, which would be the MCR 2.116C9. That does not apply where the defendant explicitly denied the plaintiff's claims. As noted in my answer to the complaint, any conceivable statute of limitations has already run. I did file my own motion for summary disposition to this effect. In response to paragraph 9, I deny the reason the same is untrue. The plaintiff did not attach the original contract between myself and the assigner, who the plaintiff had assumed Walmart. The credit card issue was one issued on behalf of Walmart. And that was out of the state of New York, Your Honor, where I had previously resided with a permanent residence. And I requested that that they provide that contract, Your Honor. I had no prior obligations to them, didn't know who they were or anything like that to be able to be held accountable for that.
You didn't know who was, sir?
The portfolio recovery associates, I had no prior communication with them to this.
Prior to this lawsuit?
Correct.
Okay. Anything else, Mr. Webb?
Not sure if this is where I should make my argument or not.
Absolutely. This is the
Okay,
moment,
yeah.
sir.
So in my defense, I don't find any merit to the plaintiff's claim, given the lack of essential contract between the assigner and myself, which should have been attached to the plaintiff's complaint. The defendant did not. I mean, I did not, under these circumstances, sorry, I did the best that I could under the circumstances and denied the plaintiff's claim. And the original credit card that's being involved in this was out of Delaware State. And their law, that was Synchrony Bank, was incorporated there. And under their law and also New York law, they both have the same statute of limitations of 3 years, which have long run since that. And this is also beyond Michigan's statute of limitations now as well. So I'm asking that the courts deny the plaintiff's motion for summary disposition and grant any other relief, whether legal or equitable, deemed. Your Honor.
Mr. Webb, when you say you did the best that you could, what are you referring to, sir?
So I originally responded to their the original thing that they had sent me, and I requested a summary of disposition on my behalf, Your Honor, prior to theirs.
Mr. Webb, I'm not sure how that answers my question. You said, when you say you did the best that you could, are you referring to your response to the complaint or something else?
In response to the complaint, Your Honor.
Okay. Anything else this morning, sir?
No, Your Honor.
Anything else, Mr. Kirschenheiter?
Yes, briefly, Your Honor. As the statute of limitations, it's a procedural issue. Michigan is the binding statute. It's 6 years for this lawsuit. There was transactions and payments within 6 years prior to filing suit on the account. We've provided documentation to that effect. We provide our motion for summary disposition has provided the assignment paperwork. No contract is necessary to be attached. This is an account stated claim. We have met our burden to show the account stated and that the amount due and owing as set forth in our affidavit. So I don't believe there's an issue of fact. I believe plaintiff has met its burden and that judgment should enter.
Thank you. The court has had the opportunity to review the motion that was filed by plaintiff's office back on March the 27th, 2023. And although the court did not receive Mr. Webb's written response to the motion, the court did take his oral argument this morning on this matter and will find that plaintiff has provided sufficient documentation to meet the standards set forth in MCR 2.116C9 and C10 and will grant plaintiff's motion for summary disposition. Mr. Kirschenheiter, I'm looking for a proposed judgment.
There's an order, Your Honor, before the it should be before the statements attached to motion for summary disposition.
It looks like they moved it to the end. The court is signing the proposed order for summary disposition that was attached to the motion. Anything else on behalf of the plaintiff?
No, Your Honor, thank you.
Anything else on behalf of the defendant?
Yes, Your Honor. MCR 2.113C1 requires that if a claim of defense is based on a written instrument, a copy of the instrument or its pertinent parts must be attached to the pleading and labeled according to standards established by the court administrative office. And that wasn't done.
Mr. Webb, respectfully, Mr. Kirschenheiter addressed that issue. This claim was brought as an account stated. The court has made its ruling. A copy of the order will be mailed to you at the address we have on file. That concludes this matter.
Thanks,
Have
Judge.
a good day.
Have a great day.
Thank you. This is 224450 GC. This is Automobile Club of Michigan versus Harris. May I have your appearances, please?
Good morning, Your Honor. Naljat Francis on behalf of plaintiff's attorney of record.
And Randall Upshaw, P number 43574, on behalf of Ms. Harris.
Good morning, Ms. Francis and Mr. Upshaw. Today is the day and time set for the hearing in this matter.
Your Honor, we have,
The adjourned pre-trial. I'm sorry, Ms. Francis, go ahead.
sorry, we have reached a consent judgment, Your Honor. It will be for the full balance. And I believe Mr. Upshaw stated that defendant does have $1,000 in escrow with the court. So for that to be turned over to plaintiff, and then $50 per month beginning June 1st. Mr. Upshaw, does that work?
Yes. Now
And
the judgment will not be entered as long as she makes the payments, correct?
For a second, let's back up. Let's back up. What, Mr. Upshaw, I don't see escrow in this matter.
Okay, if I may, Your Honor, what I'm attempting, this honorable court, and I just got into the case yesterday, but Judge, this honorable court placed my client on probation and asked her to pay.
No, sir. Mr.
No.
Upshaw, that case is
That's
in
wrong.
Washtenaw County. That's a criminal case. This is just a civil case. So if you want to take a moment,
Yes. We're gonna have
this is
to,
not that case.
okay, so what happened is, my understanding, my client informed me wrong, but the probation department is attempting to give her $1,000 back because the woman that was claiming is not the owner. So maybe we have to come back in about 2 weeks to review that matter.
Mr. Upshaw, I'll put the matter over to my next civil docket, which is the first Tuesday in June, June the 6th.
Okay,
Marianne, if you'll check my docket and get a time. Mr. Upshaw, what it is that the criminal case was Washtenaw, where she was placed on probation. Your client, Ms. Harris, was kind enough to attach a copy of an order relevant to that criminal case for the first appearance, which is how I knew there was a restitution order, but that money is not on deposit here.
okay, thank you, Your Honor. So we'll take the next court date. I believe counsel and I will work it out before June the 6th.
10 o'clock, Judge.
Thank you, Marianne. June 6, 2023 at 10 a.m. back here on Zoom, back here in courtroom number 1. Anything else in this matter, Ms. Francis?
No, Your Honor, thank you.
Anything else, Mr. Upshaw?
No, Your Honor, and thank you.
Thank you. Good to see you both. Have a good day.
You as well.
Thank you. This is 224766 GC. This is Midland Credit Management versus Michael Evans.
Good morning, Judge. Andrew Perry, P69402 on behalf of plaintiff.
Morning, Mr. Perry.
Judge,
Today
it's
is
my
the day and time set for the adjourned motion. I'm sorry, go ahead, Mr. Perry.
Yeah, Judge, it's my understanding that we mailed in a copy of the proposed stipulation. I assume the court received it with last week or two.
Mr. Perry, there was a proposed conditional dismissal that was received and rejected. The issue was that paragraph 1 said that the defendant was to pay plaintiff X dollars. The very next paragraph says that the payment was to be made to the defendant. So the court was just seeking clarification or an amendment to a correction of the order.
Yeah, Judge, it looks like we made a mistake. What I can do is I'll prepare a new proposed stipulation and send it to Mr. Evans to review and sign. That's not the intention of the parties. Judge, I'd request an adjournment.
Mr. Perry, I'll adjourn it over to that June 6th docket at 10 a.m. Of course, if you're able to secure Mr. Evans' signature on the amended conditional dismissal, just send it over. Civil Department will get it upstairs. Anything else this morning?
I do have one other file up today, Judge. 230070.
230070 GC, Midland Credit Management versus Terrence Mathis. This case was scheduled at 9 o'clock. It is now 9:17 by this court's clock. Terrence Mathis. Defendant having failed to appear. Mr. Perry, how would you like to proceed this morning?
Judge, about 5 days ago, we did send a proposed consent agreement to Mr. Matthews to review and return. It's only been a few days. I'm going to request an adjournment. Maybe that June 6th date works. And if he doesn't return it or appear at the next hearing, maybe I'll request a default.
Thank you. So, sir, we'll adjourn the pretrial to 6/6/2023 at 10:15 a.m. Back here on Zoom, back here in courtroom number 1. Anything else in this matter this morning, sir?
No, Judge, I'm all set. Thank you so much.
Thank you, Mr. Perry. Have a good day.
You too.
Thank you. These are 225886 GC, Keon Wilson and April Boykins versus Candy Bazi, Ali Bazi, and Abadisi, Abid Boyega. My apologies, sir. May I have your appearances, please?
Good morning, Your Honor. Jamal Harris, P63835, on behalf of Keon Wilson and April Boykins.
John Ivanchik on behalf of LBK Homes R Us, Candy Bazi, and Ali Bazi.
Good morning, Your Honor. Randy Lavasser, P41712, appearing on behalf of Anthony Boyega, as well as Royal Real Estate interpleader.
Thank you. There is a related case, excuse me, of 226086 GC. It was an LBK Homes versus Keon Wilson, April Boykins.
Yes. And Devin Simpson, I think, is the other one on there. He's a real estate agent.
Devin Simpson, yes, sir. Mr. Lavasser, Mr. Ivanchik, and Mr. Harris were here on this 226086 GC case back on April the 4th. And based on the pleadings, the court could not determine if these matters should be consolidated or was there a more efficient way to proceed?
Your Honor, I'm not familiar with the other case. I'm here simply because the plaintiff filed a suit against the real estate agent trying to retrieve the earnest money deposit. The real estate agent and the broker really don't have a dog in this fight, so to speak. And we're simply here because we're the ones holding the funds right now.
Mr. Lavasser, I understand that, but again, it appeared to the court that there was a common nexus of facts in both cases that tied them together. And if it's your position that you don't believe that to be true, or you have not had sufficient conversation with Mr. Harris or Mr. Ivanchik to determine if these cases should be one or should remain separate cases.
I'm not familiar with those cases. I have no opinion.
Oh, okay. So we'll proceed in the 225886 GC, Keon Wilson, April Boykins versus Bazi Abadaga. I'm sorry, I'm not gonna even try. And Mr. Lavasser's motion for interpleader. Mr. Lavasser, your motion.
Thank you, Your Honor. As I mentioned, this is basically a battle between the prospective buyer and the seller over the earnest money deposit. Our role is simply the one holding the funds. We received those funds, specifically Royal Real Estate did, when the prospective buyer, the plaintiff, submitted the purchase agreement. And unfortunately, that transaction did not come to fruition. The question is who's entitled to those funds. It's really a matter for Mr. Harris and Mr. Evanchek to battle out, so to speak. It's not really our fight, so to speak. The interpleader, we're happy to submit the funds to the court. We would ask that we be able to retain $520 for our efforts in participating in this action. That compensation is provided for by the interpleader court rule. We would also ask that upon doing so that Mr. Adeboyega be dismissed from this matter because he's unnecessary and his name is also very hard to pronounce.
Thank you, Mr. Lavasser. This court has not received a response to the motion for interpleader from anyone, although this court raised it in that semi-related case a month ago. Mr. Harris, any response to the request, Mr. Lavasser's request?
I have no objection to his request. If they are the holder of the funds, I would have no objection. I will leave that to your discretion.
Mr. Evanchek, any position, any response?
No, Your Honor, no, we take no position on this, on the motion. But for the record, the 6806 file is simply the reverse of what the 5886 file is, which is the sellers suing the buyers for the EMD. So hopefully Mr. Lavasser can take that in consideration about the consolidation motion or to consolidate the case.
The other parties taking no position, the court will grant Mr. Lavasser's motion.
Your Honor, just one other thing, we would note that if the defendants are awarded ultimately the deposit, that the listing agreement between the defendants and Royal Real Estate does provide for the splitting of the deposit between those parties. And we would simply, I don't know that we need to participate, but I do want that noted that if there's a release of the funds, that my client's interest is properly protected.
I believe that speaks to my client, Your Honor. I've spoken to her about, or spoken to them about the listing contract. My understanding is that there is a separate agreement outside the listing contract that we may have to kind of hash out in the event that this, or as this moves forward. But I don't see any need for the participation of Royal Real Estate in anything further here. As far as protecting Mr. Lavasser's client, we can certainly make him aware of any resolution. But my client, according to my client, there is some sort of side agreement regarding their portion of the EMD.
Okay. So Mr. Lavasser's motion having been granted, Royal Real Estate will now be the intervener in the case. Defendant number 3 is dismissed from the action. Royal Real Estate will retain $520 of the $3,080 on deposit pursuant to MCR 3.603E. The balance of the earnest money deposit will be placed on escrow with the court, Mr. Lavasser?
That is what we're proposing, Your Honor. If the court prefers, we can hold it as well, but it may simply be easier for us to deposit with the court.
But
If I may-
then this, Mr. Ivanchek, go ahead.
Oh, sorry. It would seem to me it would be to protect Mr. Lavasser's client. It would be simpler for him to retain the funds until we resolve this.
$520 of the money belongs to Royal Real Estate. Mr. Lavasser's office will hold the balance until there is further order from the court disposing of the earnest money deposit. Mr. Ivanchek, I heard you to say that Royal Real Estate isn't necessarily involved in this matter further.
Well, they're the ones simply holding the money. They're more or less the broker, Mr. Abbott. You know what? I'm not going to pronounce it. Was the agent. I believe Royal Real Estate's the broker, and so the broker's holding on to the money, not the agent.
I understand that, but see, this is what the problem is. When we were here a month ago, and I said to you and Mr. Harris both that Mr. Lavasser had this motion, his client seemed to be a necessary party, at least in part, and to consolidate these cases so that they're not traveling separately or moving separately. It was my hope that the three of you would at least have a conversation to figure out what the consolidation is so that we wouldn't be calling reverse parties, so that we would proceed in a more linear fashion and moving towards resolving this case, doing discovery or whatever else. I know there was some conversation about mediation with Judge Green and the 6086 case. So Mr. Lavasser's client now being addressed. Defendant number 3 being dismissed. We've resolved the money issue. What will happen next in this matter?
Well, kind of understanding, and if Vanchek doesn't disagree with that, we do consolidate both cases and move as one. So it's more efficient to effectuate a resolution in this matter.
Consolidate, and the parties appear as the 5886 case was actually the first file. So it would be plaintiff Keon Wilson and April Boykins, and defendants Candy Bazzi, Ali Bazzi, Royal Real Estate,
Well,
and go ahead.
wouldn't it be LBK Home?
I just opened the file to say LBK as defendant number 4.
I think
And where
so.
does Devin Simpson fit in?
I believe he was the buyer's agent, if I recall.
Yeah, you're suing them, correct?
Yeah, I
Suing
think my clients named him in this, and of course, Your Honor, this started as a small claims lawsuit, so we're trying to.
I know, that's why I'm
Yeah.
trying to stop and neaten it up right now. So does
gotcha.
does Devin Simpson remain in the consolidated matter?
I don't know that we necessarily need him. He's in terms of liability. It would seem that he is simply, I'm not sure why he's there, kind of for the same reason Mr. Abbott, Sam is there from Royal Real Estate. I believe that they sued everybody was named. So I think the court can dismiss Mr. Simpson, perhaps just to save our malpractice insurance without prejudice.
Okay, Mr. Lavasser, if you would submit an order that memorializes your motion being granted and how we discussed proceeding with the earnest money deposit. And Mr. Harris and Mr. Vanchek, if you would prepare your order consolidating these cases, removing defendant number 3 from the 5886 case, removing the 3rd defendant from the 6086 case. There had been prior discussion about this matter going to Judge Green for in-house mediation. Is that still how you wish to proceed, Mr. Vanchek?
It is, Your Honor.
And same for you, Mr. Harris?
Yes, we can move to mediation.
Thank you. Once I receive the orders disposing of the interpleader motion and the consolidation of the cases, I will send the matter down to Judge Green. She will reach out to you directly to schedule the in-house mediation of this matter. Anything else, Mr. Lavasser?
Nothing further, Your Honor.
Anything else, Mr. Vanchek?
No, thank you, or nothing, Your Honor.
Anything else, Mr. Harris?
Not at this time, Your Honor.
Thank you so much. That concludes these matters. You all have a wonderful day. Thank you.
Thank you.
Okay.
Enjoy the rest of your day, Your Honor.
You too. This is 220765 GC. This is Sun Home Services versus Jason Nicholas and Rusty Nichols, I'm sorry.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
Good morning, Mr. Kuipers. Jason Nichols or Rusty Nichols?
Your Honor, this
Today
was
was the day
actually
and
a
time set for
motion.
your show cause, Mr. Kuipers. I'm sorry, go ahead.
This is actually a motion for show cause against an employer, so it'd be for right on.
Yeah, my name is Ali Fawaz. I'm with Right On.
Have you spoken to Mr. Kuipers this morning?
I have not spoken to anyone.
Mr. Kuipers, you'll see an invitation, and Mr. Fawaz, you'll see an invitation going to the breakout room to discuss this matter. When you come out, I'll recall the case, okay? Thank you.
Where's that at?
You'll
Oh,
see
there
a
it is.
button that says join the breakout room. This is 231808GZ. This is Robert S. Joseph versus Romulus Police Department and J&M Towing. May I have your appearances, please?
Robert Joseph, appearing pro se.
Good morning, Your Honor. Thomas Stidham, appearing on behalf of the defendant, J&M Towing Enterprises. And I have a representative of J&M with me as well, Your Honor.
I see her. Thank you. Today is the day and time set for hearing on the plaintiff's petition. The petition received by the court indicates that Dr. Joseph is challenging the vehicle being deemed abandoned or removed. Dr. Joseph, please proceed with your petition.
Yes, ma'am. I'd like to call Anna Maria Joseph, please, as a witness.
I'm sorry,
Hi,
Dr.
that's me.
Joseph, have you spoken? Not yet, ma'am. Dr. Joseph, have you spoken with Mr. Stidham about this matter?
No, ma'am.
Mr. Stidham, would that be beneficial at all?
I'm always an eternal optimist, Your Honor. I have no problem speaking with Dr. Joseph.
Thank you. Mary Ann's gonna send an invitation for you to go into the breakout rooms. That might be helpful before we swear witnesses and start taking testimony. Mr. Warner, have you spoken to Ms. Hutchins?
Your Honor, I have not.
Let's get you into a breakout room with her.
Thank you.
Thank you. Ms. Hutchins,
Yes.
you should see an invitation to go into a breakout room with Mr. Warner. Please go with him to discuss your objection to garnishment. When you come back out, I'll call the case.
Okay.
Thank you. Ms. Joseph, your hand is up.
Your Honor, would it be possible for me to also join the breakout room, please?
Are you a party to the case? I don't see your name listed on the file anywhere.
It was part of the code.
Your audio is not consistent, ma'am. I'm sorry.
Now, Your Honor. Your Honor.
Ma'am? I can't hear you. Ms. Dixit,
Yes, Judge.
we'll get you into a breakout room with Ms. Hall, okay?
Judge, I just spoke to Ms. Hall.
Oh, okay.
Yeah.
While we have a lull, let me get your case called, man.
Okay, thank you.
This is 193216 GC. This is Franklin Hills Apartments versus, nope, let's try it again. This is 224720 GC Westlake Services versus Hall. May I have your appearances, please?
Yes, good morning, Your Honor. This is Natasha Dixit on behalf of the plaintiff. My P number is 82333.
Thank you. State your name for the record, please.
My name is Alicia Hall.
Thank you. Today is the day and time set for the pretrial in this matter. How are we proceeding this morning?
Yes, Judge. I did speak to Ms. Hall and we have reached an agreement. I explained that I will be sending her the settlement agreement to sign, and once she reviews and signs it, we'll send it to the court. Sherman Law Group will send it to the court.
And that agreement will be the terms of it?
Yes, Judge. It will be a conditional dismissal. Oh, I'm sorry. Yes. Oh, I'm sorry, Judge. Yes.
Conditional dismissal with what terms?
I can give you the exact terms, Judge. The settlement terms. So it would be settlement of $11,900. And if she, like I explained to her, as long as she makes the payments on time, we'll keep the case dismissed. And if she defaults, she'll get an affidavit of non-compliance. And if she's not current, we'll request the court enter a default judgment.
Because the parties have just reached the agreement, it is not yet executed and ready for submission. Ms. Dixit and Ms. Hall, what the court will do is adjourn this matter. The new court date will be June 6, 2023 at 10:15 a.m. back on Zoom, back here in courtroom number 1. In the meantime, Ms. Dixit, if your office sends Ms. Hall a conditional dismissal and the parties sign it and get it back to the court, I, of course, will sign it and you don't need to appear. That June 6th date is more of a control date to make sure that the document does get executed and submitted to the court. Anything else, Ms. Dixit?
Oh, no, just to clarify, it was June 6th at 10:15 a.m. And
yes.
And if received before that, it will be adjourned, canceled, basically.
Absolutely.
Okay.
Anything from you, Ms. Hall?
Yes, so you said for June 6th, I don't have to be present, or do I have to be present onto the Zoom call?
You do not have to come back for the June 6th, 10:15 case. It will be on Zoom if we need to have it. But if you sign whatever the conditional dismissal with Ms. Dixit, they'll send it here. I'll sign it within a day or two of it getting here, and then copies will be mailed to you. So if you get a copy of the signed conditional dismissal with my signature on it, you'll know that this matters are resolved and you do not need to come on June 6th.
Okay, yes, ma'am, understood.
Okay, thank you much.
All right, thank you, Judge.
You're welcome.
Have a good day. Thank
All right,
you.
thanks.
You too.
Allegedly.
That's what I think.
What else is going on?
Nothing. That's the only case we haven't.
You see tomorrow?
No, I haven't seen.
It's not. I'm not gonna say it. We've already had one exam adjourned.
That's our hard day tomorrow.
Yeah. You're supposed to keep track of that stuff. I don't know if that's sad or funny, but thank you. Mr. George,
Good morning, Your Honor.
good morning. What are you here for, sir?
I'm here for a hearing on Karina Rogers.
Frida Rogers?
Karina Rogers.
Oh, thank you. I have your response to the motion. They just did not add your appearance.
It's our motion, Your Honor. If I
know, but
failed,
it would, no, you're fine. You're
Okay.
fine. Oh. This is a recall of 2318008GZ, Dr. Joseph versus Romulus Police and J&M Towing. The parties have been into the breakout room. Dr. Joseph, any resolution of this matter? Are you ready for the hearing?
We would like to add the Wingate Hotel, 9501 Middle Belt Road, Romulus, Michigan, 48174, as a co-defendant.
The defense has no objection to that, Your Honor. I think it would just, I think, given the facts, the plaintiff believes they may be an essential party and it would accord complete relief in one proceeding. So we have no objection to that.
I'm sorry, and Dr. Joseph, that address again?
Yes, ma'am. 9501 Middle Belt Road, Romulus, Michigan, 48174.
Court makes notation in the file that Wingate Hotel is a necessary party, will be added to this matter. The court will need to adjourn and renotice this case for June the 6th at 10:30. 10:30 a.m. on June the 6th, back on Zoom, back here in courtroom number 1.
Your Honor, I understand June 6th, courtroom 1 at 10:30 a.m. Is that correct?
Yes, sir.
Thank you, ma'am.
Anything else?
Nothing
Anything else, Dr.
time.
Joseph? Thank
Nothing
you.
at this
Anything else,
time,
Mr.
Your Honor.
Stidham?
No, Your Honor.
Court staff will send notice of the new date out. Everyone have a good day.
Thank you. You as
Thank
well.
you. Thank you, Your Honor.
Thank you.
Ms. Fowler, you can sign off.
Okay, thank you.
And we will sign off.
This is a recall of 220765 GC Sun Home versus Jason Nichols, Rusty Nichols, the garnishee defendant, Sun. Right on Inc. I have your appearances, Mr. Kuipers. You've had an opportunity to discuss this matter with Mr. Fawaz.
I did, Your Honor, and I was actually, I actually got kicked out of the break room, but just to inform Mr. Fawaz, I did speak with the attorney of record on this matter, and based on Mr. Fawaz's representations, the defendant has never worked there. They've never paid him any income. He's never been an independent contractor or anything really of that nature. We are withdrawing our motion.
Motion withdrawn. That concludes this matter. Anything else, Mr. Kuipers?
No, Your Honor, that is it. Thank you very much.
Anything else, Mr. Fawaz?
No, thank you very much.
Thank you. Have a good day.
You as well.
Thank you. This is 193-216 GC Franklin Hills versus Ariel Hutchins.
Yes.
May I have your appearances, please?
Yes, good morning, Your Honor. Robert Warner, P 48843, appearing for the plaintiff, Franklin Hills Apartments.
Ma'am, state your name for the record.
Ariel Hutchins.
Ms. Hutchins, today is the day and time set for hearing on your objection to the garnishment. You've had a chance to speak to Mr. Warner.
Yes, I have.
Have you reached any agreement?
Yes, we did.
We did.
Mr. Warner, that agreement is?
Yes, we'd like to enter into an installment payment order, obviously as soon as possible. And the terms of that will be $200 per month beginning June 5th, 2023, and by the 5th of every month thereafter until the judgment balance is paid in full. And that's our agreement.
And as for the garnishment currently in place with Henry Ford Health System?
That's correct. We're hoping that installment payment order would suspend that garnishment in lieu of the payment arrangement.
Suspended in any withheld funds?
Yes, with withheld funds to be released to the plaintiff and then just suspended.
Is that your understanding, Ms. Hutchins?
Yes.
The court will enter an order directing the garnishee to release any withheld funds to plaintiff, thereafter suspending the garnishment and entering a payment plan of $200 per month beginning on June the 5th, 2023, and the 5th day of each month thereafter until the judgment is paid in full. Anything else this morning, Mr. Warner?
I have nothing further, Your Honor. Thank you.
Anything else, Ms. Hutchins?
No, Your Honor.
Thank you. That concludes this matter. You both have a good day.
You too. Thank you.
Thank you very much.
Thank you. Mr. Morton, have you spoken to Mr. George?
No, I have not, but that sounds wonderful and exciting. So if you put us to a breakout room, I would be more than willing to do so. I do have one other case. It was at 9:45, but I don't see the other party. And it's a motion for entry of a writ, which they may or may not even still be there. So that one can, we'll wait for that one.
I don't know how I feel about you thinking that it sounds exciting to talk to Mr. George, but. Mary Ann?
Morning, sir. Can you hear me?
Yes, ma'am. I just can't see you now. I don't know what happened.
That's okay. What is your name, please?
DeAndre Harper.
Thank you.
This is 230799 LT. This is Anmark Concord Club Apartments versus Karina Rogers. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff and Mark.
Good morning, George of Lakeshore Legal Aid on behalf of Karina Rogers. Your Honor, I do note that it's a little bit before 10 o'clock, and I think this was scheduled for 10. Would it be okay if we just waited a few minutes to see if Ms. Rogers appears?
Absolutely.
Thank you.
And Your Honor, just for the record, the parties spoke, at least between the attorneys at this moment. We have not been able to reach a resolution. We definitely had a constructive conversation.
Thank you. Mr. Morton, did you want to confirm whether or not Ms. Lewis was still in the property, or do you want to wait a few more minutes to see if she appears?
Yeah, we could go ahead and give her the full, I always say 15 to 30, whichever the court wants to do. But I would say, yeah, let's give her the full 15.
Okay, thank you.
Thank you.
Good morning, ma'am. You're muted.
Good morning.
Your name, please.
Virginia Owens.
Thank you.
Your Honor, this matters, I'm handling this matter as well. That's Country Meadows. That one's scheduled at 10:15. It's a motion.
I see that. Thank you, sir. This is 225063 LT. This is Holiday Woods versus Rashana Lewis. May I have your appearance, sir?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of Holiday Woods.
Thank you. This matter was scheduled at 9:45 this morning for hearing on plaintiff's request for entry of an order of eviction. It is now 10 a.m. by this court's clock. Defendant having failed to appear, Mr. Morton, is your client still seeking issuance of that order?
Yes, they are, Your Honor. It's in a manufactured home community, but is a rental home. They've tried to confirm if anybody's still inside of it, but they've been unable to do so. The keys were never returned. They tried to initially work with the person on getting a payment or payment arrangement. But however, nothing had ever been worked out. And that's why the 56 days had expired. So therefore, they're requesting that the order of eviction be entered as to be able to take possession of the rental unit.
Thank you, Mr. Morton. The court is signing the order granting the motion for issuance of an order of eviction and signing the order attached thereto. The file will be downstairs shortly for the civil department to process that order. If you would like to take a moment to go into the breakout room to meet with Ms. Owens, we'll see if Mr. George's client appears.
Sounds good, Your Honor.
Thank you. Ms. Owens, you'll see an invitation to go into a breakout room with Mr. Morton. Please go there with him.
I accidentally declined it. Can they send it back to me?
Absolutely. Hold on.
Thank you.
Mr. Ivanchuk?
Yes, Your Honor. Right, I'm here on the Urban Stewart. I don't see opposing counsel yet.
I don't know if Mr. Perry left with intentions on returning. It's scheduled at 10. My policy is about 15 minutes after the scheduled start time.
Well, if I may, Your Honor, we have resolved it, but I don't have any paperwork, just emails.
Then it's not resolved if there's no paperwork.
I would tend to agree with you. We'll wait. I'll try. I was going to try to catch Mr. Perry, but he said he was only here on 2 cases, and I've been communicating with the paralegal, so I'm not sure who's supposed to be here.
Oh, okay. Thank you.
Yep.
Mr. George, did you need to speak to Ms. Rogers?
Yes, please.
She is in our Zoom room on site. Mr. Burcroft, if you'll help her get into the breakout room, her attorney wants to meet with her.
Sure thing, Judge.
For me, okay.
Thank you. Hey. Shoot. So we're not doing civil on July the 4th. We moved it to July 18th. Can't believe I got that right. Which part?
He doesn't have to be on Zoom.
No. No.
The other ladies.
Because when you tell me something's settled, it's not settled until there's paperwork here.
He said it's out.
3 weeks ago. Wait a minute, that doesn't even sound right.
Maybe you don't think he has.
On April 14th. If I've seen paper, you've seen paper, so yeah, no. No. What's going on?
Nothing. Quiet.
Don't say that. Are you ready for Friday?
No, but we'll get
What do you
there.
mean, no?
Did you find where you were looking?
No. Jamie said he thinks it's over there, but I said, wait, I think I'm gonna use this poster board to put the art projects on. I already hung one in there. I think that'll be okay, but there's gonna wind up being like 5 or 6 of them. But there's a long stretch of wall. It's just a matter of getting it done, which is,
You know, we probably could go over there and look and see if they have a big one, but. you're
but
gonna
then
have to
you'll move it
tape
over
them.
here. Yeah, they are taped to the poster board.
Oh, okay.
But once you move it over here, then it's gonna be stuck somewhere and we need another piece of whatever over here, you know.
Another relic.
I'm not going to add to it. It's just right now, it's just poster board on the wall and then there'll be a way for people to vote. But I just,
They would just throw it in the garage.
oh, and see, I don't want to be part of that. I'm just trying to get it on the wall so that it is not taking up space. I was just gonna put paper on the bulletin board and put edging on it, but then that means that people have to be reminded to look on both sides, and then it's gonna be stuck over there, or it'll be stuck in the back of somebody's, you know, and I just can't, I can't be party to the clutter. I refuse.
Are they on the time clock or no?
Who?
These guys?
10:15.
Okay.
Everybody, it's always 15 minutes after the hour as close as possible, and that's why I'm calling 230-748 LT Country Meadows versus Virginia Owens. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton, Appellate's Law on behalf of Country Meadows.
State your name for me, please, ma'am.
Virginia Owens.
Thank you. Today is the date and time set for hearing on the defendant's motion to set aside default judgment. The parties have had an opportunity to speak. Mr. Morton, do we have any agreement in this matter?
No, Your Honor, we have spoken. We've been unable to reach a resolution on this matter. Was that I did advise Ms. Owens that she would be able to have the opportunity to be able to argue her motion at this time. I would just clarify one thing for the court, that there are two cases going currently. One is a non-payment case, which the judge was entered. There's also a termination for just causes. This involves manufactured housing in which Ms. Owens is the owner. But I will let Ms. Owens make her statement after you've given direction, Your Honor.
Thank you. Ms. Owens, this court is aware of the fact that there is another case, that being 231422 LT, scheduled tomorrow morning at 10 a.m.
Yes.
Which is, in fact, as Mr. Morton indicated, the termination of tenancy. For this non-payment of rent default judgment, ma'am, please present your motion.
Well, there was some confusion when the first court case had come, and somehow I got put into the wrong Zoom room. And then when I called the courts, they weren't sure. So I apologize for not being at the previous session. But I wanted to make sure that, you know, my side of the story was heard, because I don't feel like legally it should be my.
You muted yourself.
I'm sorry.
You
Can you
don't
hear me
feel-
now?
That's okay. Yes, ma'am. You don't feel that
I
legally.
can't hear
what?
you.
Can you hear me now?
I can't hear you. No.
Mr. Morton, are you able to hear me?
I can hear you now. I don't know what happened.
Okay.
Yes, Your Honor, I can hear you, and I can hear Ms. Owens as well.
Ms. Owens, you were saying that you don't feel that legally.
Yeah, legally, like I feel like I moved out when they told me to move out. I've been out since. I've been back several times to fix things up or whatever. Now, like I was telling the attorney, you know, when I first moved in there, I've been there for about 8 years, and Vanessa, the manager at the time, like I was debating, you know, should I rent or should I buy? And I was trying to build my credit at the time. So she told me, you know, buying is better. And I said, well, I'm worried about selling it when I need to sell it. And she gave me her word that they would buy it from me. But now they're telling me they won't buy it from me. Vanessa said that not Vanessa, I'm sorry, Chris at Country Meadows said that my balance due has to be paid in full before they'll even accept the application. So my rent is just going to keep piling up. And the fact that they evicted me for a dog incident, that my dog isn't even here. Like, I surrendered my dog. It was an accident. It happened. It shouldn't have happened. And I took responsibility for that. I got tickets for that. You know, it was an accident, and they're evicting me, and the dog's not even there anymore. Like, that's my biggest thing. Like, I had to get rid of my dog that I've had for 8 years because this girl came up and tried to pick her up or whatever had happened. You know, my dog did get out. So I took responsibility for that, though. And when I surrendered my dog, I feel like that should have been the ending of the eviction. Like, they shouldn't have even thought about that. But when I went to talk to Mike about it, he was yelling. He slammed his hands on the desk, told me a bite is a bite. It doesn't matter. This is irresponsible. And I just told him, I said, I'm not listening to this. I am a human being. I'm not going to be talked to like this. And I walked out, and 2 days later, I had an eviction notice on my door. Like, my dog was already surrendered. And now I'm a single mom. I had to come up with $4,500 to move, plus moving costs. That was just the down payment and first month's rent for my new place. And I have to pay my mortgage and lot rent still because they decided not to give me a chance.
Ms. Owens, there's actually, as Mr. Morton indicated, there are two separate cases. The termination case for tomorrow is about the bite. Today's case is just about the non-payment of rent. And it is your motion to set aside the default that entered back on April the 13th based on solely on your failure to appear at that adjourned date. Your motion indicates that you were given incorrect Zoom information, or you were placed in the incorrect Zoom.
Right. So that's what I'm saying. I wasn't able to attend that meeting. I went and sat in that Zoom room for 15 minutes and then nothing happened. So I called the courts, and somebody at the court told me that they didn't see a court case for today. I don't know if they were getting the two mixed up and only seeing the one. I think it was February 12th, that case, but they only seen the one case in the computer system. So they couldn't get me at the right location. But I understand that this is for the non-payment of rent, but I think they're tied together. If I was evicted wrongly, I wouldn't be behind on the rent. You know what I mean? Like if they would have talked to me and come to a conclusion with my dog being put to sleep already, then I would have been there and paying my rent like I always have. But when you're a single mom, you can't just, like, I had to find somewhere for me and my kids to live. So I had to take every dime that I had, put it down on this place. And now I am paying $1,600 a month in rent instead of $1,200. And I can't afford both of them. And then they won't even buy it back from me to stop the rent from accumulating.
Anything else, Ms. Owens?
No, I don't think so.
Mr. Morton?
Your Honor, I'm not gonna, argue in regards to some of the communications I had with my client. My clients made statements to me about the accuracy of those, but I don't think I'm not gonna go into those things. Was it because my client's not here to provide specific information in regards to that? However, I would just specifically focus in on the two areas of law in regards to being able to set aside a default judgment. One is the fact that there has to be grounds of the reason why she didn't appear. She's presented that, and there has to be grounds of why the payment wasn't made, an actual defense of that there's a past due balance. There's been no defense that there is a past due balance and that balance is owed, Your Honor. The fact is that there is, that amount that was entered back, in March was around 3,700 and that balance has not been paid. I don't believe there has been any good faith funds put into the court as well to be able to try to say that this is only not related to not being able to pay those funds. So based on that, Your Honor, we would seek that this motion be denied as again, Your Honor, there's no argument about the fact that the past due balance is still in place. And if the court would consider setting it aside, we would ask that it be contingent on the fact that the judgment amount, or at least half the judgment amount, be placed into the court's escrow to show a good faith argument of the non-payment case.
Anything else, Mr. Morton?
No, Your Honor.
Thank you. Ms. Owens, do you dispute the amount of $3,793.27 being due as of April 13, 2023?
I dispute it as far as I feel like I should not have to pay it, yes. Do I dispute it as far as that's, the rent of the property? Yes, it is the rent and it is technically due, but I do feel like I should not have to pay that.
Anything else, Ms. Owens?
No, Your Honor.
Thank you. The court has had the opportunity to review the motion filed by the defendant back on April 24th, 2023, and hear the arguments of the parties this morning. And Ms. Owens, the court typically is very understanding of people being either misdirected in Zoom or having difficulty navigating Zoom. And typically, if a party is not able to participate and they dispute the judgment that entered in their absence, the court would reschedule the matter for additional hearing. But inasmuch as you acknowledge that the rent claim due and owing is accurate, the court is going to deny your motion to set aside the default judgment that entered back on April the 13th, 2023. Anything else, Mr. Morton?
No, Your Honor. Other than the fact, would the court like me to submit a proposed order to the court?
Would you please, sir?
Absolutely.
Anything else in this case, Ms. Owens?
No, I guess not.
That concludes this matter. Ms. Owens, good luck to you. Have a good day. This is 230799 and Mark Concord Club Apartments versus Karina Rogers. May I have your appearances, please?
For the record, Your Honor, Ian Morton of Palace Law on behalf of Ann Mark.
Good morning again, George of Lakeshore Legal Aid on behalf of Karina Rogers, who is present in the Zoom courtroom.
Thank you. Today is the day and time set for hearing on the defense motion to set aside the default judgment in this matter. The parties have had an opportunity to speak. Do we have any agreement in this matter?
No, Your Honor, we've not reached a resolution.
Mr. George, please proceed with your motion.
Thank you, Your Honor. This is our motion to set aside the default judgment. Ms. Rogers was in the hospital on the day of the hearing. She did attempt to contact the court and inform them. I'm not sure if the court saw the note in the file. But we did include the discharge papers with our motion to show that she was in the hospital at that time. Additionally, Ms. Rogers does have meritorious defense. There are many repair issues with the property, several of which go to habitability and safety, including a month where Ms. Rogers was without heat during the winter, and outlets that spark when you use them, windows that do not open and prevent her from escaping in the event of a fire. Ms. Rogers wants to have her day in court. We're requesting that this court set aside the default judgment and set this matter for a new trial date so that we can file an answer and hopefully get some of these repair issues taken care of.
Mr. Morton.
Your Honor, my client's belief is the fact that Ms. Rogers is making this argument in bad faith. Ms. Rogers has changed the locks inside the home on the unit itself, denying my client access, and then she has failed to provide keys to that unit. Was it to provide my client access, even though she claims that there are alleged condition issues. In addition to that, Your Honor, there is over $5,700 past due and owing on the balance that's due. And we question whether or not she even has the ability to make those payments. Or has the ability to even pay any of those amounts. Again, Your Honor, this is a case in which that, she's provided the medical documents. So, I don't have any reason to question the validity of that medical document, but I do have a question. We do think it's appropriate that this court consider the fact that, again, my client as stated in our response, does not have access to the unit. The locks have been changed without permission, which is against the lease. Was that my client cannot investigate matters if they don't have access to the unit, as well as when my client has attempted to gain access to the unit, they've been sent away on multiple occasions. If the court, if the court's going to consider setting this aside, we would ask that first that the entire judgment amount which was entered back on 4/10 of $3,557 be required to be placed into escrow, was to show that she's actually trying to make a good faith argument and does have the capability to pay this balance, as well as require that she provide keys to the unit to my client the next 2 business days. In addition to that she does not restrict client access, as she is claiming that there's so many condition issues that it makes it, the habitability in question, but then the question goes to is why she's limiting access to my client to be able to do any of those things. So again, we would ask that if the court's going to consider setting it aside, $3,557 be placed into escrow in the next 7 business days, that a copy of the keys become provided to my client in the next 2 business days, and that she allow my client free access to the unit to be able to investigate, first of all, these alleged repairs. If any of those things aren't allowed, my client is put at a severe disadvantage. Again, we think that Ms. Rogers is making these arguments and these statements in bad faith.
Before Mr. George responds, is there a listing or an agreement between the parties of what the issues are that Ms. Rogers is alleging? Not necessarily that they actually exist, but is there some agreement or some understanding as to what maintenance issues Ms. Rogers is claiming?
I would say, Your Honor, my client doesn't have access to the unit, so it's hard for them to have any sort of agreement on what's outstanding. I know that the motion was filed that I believe it referenced some of those things. Is that correct, Mr. George?
Yes, that's correct, Mr. Moore.
Yeah. So I believe those are listed in the motion itself. Some of those issues are listed in the motion itself. But again, Your Honor, I can't necessarily agree to anything, especially when my client can't gain access to the unit.
Mr. Morton, before Mr. George responds, I'm not sure what listing you're talking about. The court has the discharge papers and then copies of some handwritten notes that are largely illegible. Is that where you're saying there's a listing?
I think it's inside the
repair issues.
I think that's where the alleged repair issues are. I know we were able to make out some of it, Your Honor, but you're right. Looking at it, it's like the top is somewhat clear and then it gets faded as you go down. So if the court's gonna, again, besides my requests, then it would make sense that a list be provided as well. So my client, when they investigate these alleged issues, knows what they're looking for. But again, they need to be able to gain access to the unit to be able to do so.
Thank you. Mr. George, your response to Mr. Morton.
Thank you, Your Honor. As far as the key issue, Ms. Rogers did change the locks due to security issues. People were getting into her apartment when she was not there. I have no objection to the court directing her to turn over the keys. I've advised her to do so regardless of the court's decision today. As far as the escrow goes, these defenses, like I said, we want to get these things fixed. I'm more than happy to work with Mr. Morton, send him over a complete list of everything that we want them to take a look at. As far as the escrow goes, because of these meritorious defenses, I don't believe that an escrow would be necessary in this case. If the court does determine to impose an escrow order, I would ask that it be limited to just 1 month, 1 month's rent.
Anything else, Mr. Morton?
No, Your Honor, what was it? I feel like I've said bad faith enough, so I think the court understands my client's viewpoint. So I leave it to the court at this time.
Anything else, Mr. George?
Nothing further at this time, Your Honor.
The defense motion to set aside the default judgment is granted. The court will find that the defendant has met the proper standard in this matter. The order to set aside the default judgment shall indicate that Ms. Rogers is to turn over a copy of the key to the plaintiff by 5 p.m. on May 4th, 2023, that she will deposit $1,750, which is half of the judgment amount, to the court within 7 days. Mr. George, I hear your allegations that there are these maintenance issues, but there remains a value to having shelter. And as much as Ms. Rogers continues to occupy the unit, there's value there. So $1,750 escrow to the court within 7 days. Mr. George will file an answer, if that's what you indicated previously, sir, within 14 days, and the parties will return. The answer will include a specific list of the alleged maintenance issues. And the parties shall return for a hearing on May 17th, and I know that's wrong. May the 24th, 2023, 24, May 24, 2023, at 10 a.m. to take up the non-payment complaint, unless there's something else that needs to be addressed at that time. Mr. Morton, anything else?
I would only ask, Your Honor, will the court entertain entry of a default judgment if that escrow payment is not made or if the keys are not provided and the timeline is provided?
Absolutely. I'm sorry, Mr. Morton, that's what it was. It was 2 days for keys, 7 days for escrow, 14 days for order. Mr. Morton, if you can prepare an order that lists those things and further indicates that should any of these things fail to be completed in the time required, court will enter judgment, default judgment.
Understood, Your Honor. I'll prepare that, send that over to Attorney George for him just to review and confirm, and then we'll get that submitted to the court.
Anything else, Mr. Morton?
No, Your Honor.
Anything else, Mr. George?
No, Your Honor.
That concludes this matter. Good luck to you, Ms. Rogers. You may exit that room that you're in through that door on your left, okay?
Thank you, Your Honor.
Thank you. This is 225963 LT. This is the estate of Michael Miller versus Francina Canada Buchanan. Hi, state your name for me.
Francina Canada Buchanan.
Ms. Buchanan. We were last here. We were last here on February 22nd, 2023, and the court adjourned the trial to April 4th, 2023. The court received notification from Mr. Robinson, I believe the day before, indicating that this matter had been resolved and that there will be paperwork forthcoming. This court has not received any documentation settling and resolving this matter. On April the 14th, the court asked the civil department to renotice this matter for in-person trial this morning at 10 a.m. to again take up the allegations. It's now 10:32 by this court's clock. Mr. Robinson is not here. Mary Ann, have you had any communication from Mr. Robinson?
No, ma'am, I have not.
Ma'am, have you had any communication from the attorney?
I've received 3 emails from March the 8th, our trial date in circuit court. First of all, in court, he said that he was going to be sending the paperwork to dismiss this. Maybe about 2 weeks later, he sent another email and said that he was working on it. And then we closed on the home on April the 6th. And on the 4th, he emailed, no, that might have been, whatever day was Monday.
I'm sorry, you closed on April the 6th?
We closed on April the 6th, which is my birthday. He emailed to say that he was taking care of this matter. I thought that this paper was the dismissal, and then, so I just got it yesterday.
What paper?
The notice.
The notice to show up.
Yeah, because it's routed to my old address and it's supposed to be forwarded, which takes extra time. So when I opened it, I just showed up here today. I do have the property transfer affidavit to show you that at least that was filed with city of Sumter as proof that I have closed on the property and it now belongs to me. The judge demanded it.
Ms. Canada Buchanan, my memory of what the status of the circuit court matter is a little fuzzy. But based on Mr. Robinson's failure to appear this morning, based on the fact this court has not received any additional documentation, and your assertions that the closure that had been dictated in the 2020 circuit court case has now happened, the court will enter an order dismissing this matter without prejudice. Mr. Robinson is free to bring the matter again if necessary, but other than that, the civil department will prepare an order dismissing the matter and mail it to your attention. Is the Harris Road address the correct address?
No.
What's the correct address?
10339 Talladay, Talladay Road, Willis, Michigan 48191.
I'm writing that in the file so that the civil department will know to update your address so that you receive a copy of the dismissal. Anything else?
No, that's it.
Thank you, ma'am.
Thank you.
Congratulations.
Thank you. Took 3 years, Your Honor.
But what a blessing, right?
Yes, it is.
This is 230350GC. This is Midland Credit Management versus Irvin Stewart. Your appearance, please, sir.
John Ivanchik on behalf of the defendant, Your Honor.
Thank you. Today is the day and time set for the first pretrial in this matter. This case was scheduled at 10 a.m. Sir, I received your communication that you've not received any response from opposing counsel. How would you like to proceed this morning?
Well, as indicated earlier, Your Honor, I believe we have an agreement. I've just not gotten any paperwork on it. I emailed the person that I've been communicating with, which I believe is a paralegal, about attendance this morning. I emailed who I think is the attorney responsible for the file and didn't receive an answer. I called their office, you can't talk to anybody, so I left a message. I will leave it up to the court's discretion as to what to do from here.
She's here now, Judge.
Oh, all right, there we go.
Liz Smith is joining. I see her audio connecting right
All right.
now.
Saved by the bell.
Ms. Smith?
Yes, good morning.
Good morning. I just called the case. Mr. Vancheck indicates to the court that in the matter of Midland Credit versus Stewart, there's an agreement in principle between the parties.
That is correct, Your Honor, yes.
How long would it take to get the paperwork executed and submitted to the court?
We could likely get that wrapped up electronically, at least by the end of the week.
Reasonable, Mr. Vancheck?
Yeah, that's fine, but is the court gonna set it as or just no further dates from here, or?
Oh, no, we'll do further date because just more of as a control measure than anything else. The court will adjourn the pretrial out to June 6, 2023 at 10:30 a.m. So back here in courtroom number 1, back on Zoom, but so long as the parties get their settlement agreement executed and submitted, the court will of course enter that and take this matter off of the docket.
That works for me, Your Honor.
Anything else, Ms. Smith? I'm sorry.
No,
Ms.
Your Honor, apologies for being late. We were just advised of the hearing and I logged on 5 minutes before now, so I apologize.
Thank you, ma'am. I'm sorry, sir. I cut you off. What were you starting to say?
Oh, I was just saying, as soon as I get the paperwork, we should be done. I can send it out for e-signing, so.
Okay. Well, thank you both for your patience this morning. I hope not to see you on June 6th.
Thank you, Judge.
Thank you, Your Honor.
Thank you. This is 191428 GC. This is Westchester Towers versus Watkins.
Good morning, Judge. Christopher Asphalt, 53129 on behalf of the plaintiff.
Good morning, Mr. Asphalt. Today was the day and time set for hearing on the defendant's motion to amend the payment plan. This matter was scheduled for 10:15. It's now 10:38 by the court's clock. I thought that we had seen. Maybe not. Oh, no. Okay. The defendant having failed to appear, Mr. Asphalt, how would you like to proceed?
And Your Honor, I would request that her motion be denied and that I will submit an order denying the motion as well as setting aside the previous installment payment plan that was entered by the court pursuant to the affidavit of non-compliance that we previously filed with this court and served on the defendant.
Thank you. Defendant having failed to appear as ordered by this court, the motion to amend payment plan is denied. The plaintiff's request to set aside the previously entered payments plan is granted. Sir, if your office will submit an order to that effect to the court, I will sign it. Anything else this morning?
No, Judge.
Thank you much for your patience. Have a good day.
Thank you.
This is 214360 SC. This is Richard Williams versus DeAndre Harper. May I have your appearances, please?
What?
State your name for the record, Mr. Williams.
I am the plaintiff. My name is Richard Williams.
Thank you. Mr. Harper, state your name for the record.
DeAndre Harper.
Thank you. Today is the day and time set for discovery in this matter. Mr. Harper. Mr. Harper,
Yes, ma'am.
please present to the video. Thank you. Raise your right hand, sir.
Sorry about that.
That's okay. Do you swear or affirm testimony you're giving this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down. You'll see an invitation to go into the breakout room with Mr. Williams. This is a discovery proceeding where he'll have the opportunity to ask you questions about your assets and your resources to make payment on this judgment that previously entered. You'll see an invitation to go into that breakout room. Mr. Williams, whoever that is with you will help you get into that room. Please go in there and ask your questions of Mr. Harper, and when you're ready, come back out, please.
This is literally, you realize, sir, that you gave her permission and she didn't state it. Whether I'm in your ward or not, sitting on that board, supposed to be
He's not here. There you go.
What did he do? He left?
No, you're with the judge now.
He's with the judge.
You're with the judge.
Mr. Williams, I'm just waiting for Mr. Harper to come back out.
Yes, ma'am.
Thank you. We're still on the record in 2143660SC. The parties have had an opportunity to speak. Mr. Williams, did you get the information you were seeking, sir?
No, he's refusing. To give me.
I'm not refusing. I gave everything.
Hold on,
that
Mr. Harper. Hold on for one moment.
Okay.
I'm sorry, Mr. Williams, you were saying he's refusing?
Yes, he refusing my asking for his social security